for those that don't know me, my name's Lacey Nazell. I work for Witset First Nation as the executive assistant. I have been in this position for the past 2 years, but I've worked for the nation since August 2011.
My name is Sonia Piggin. Howdy, everybody. I belong to the Anasaski House of the Gidimt'en clan, and I am so happy to be here working with the community on hopefully a new election code that will apply to Witset moving forward. It's not something that happens overnight though, and it is like about a 2-year project. So I know there's an election coming up and you won't get the benefit of this code being in place yet for this election, but in the future, I think that if you go through this process, you'll be much happier with the transparency around how things work for chief and council and feel that you have it set up in a way that works for you. We'll be doing a bit more of an opening in the in-person meetings, so that's what that slide is. And again, we already talked about the agenda for today. We won't be looking at campaign offenses or candidate eligibility, but the rest of the topics on the screen we will be looking at. Just going to talk a little bit about the structure for the meetings. If you attend the in-person meetings, we're going to be doing a lot more team discussion and breakout teamwork. So we will be setting the room up a little bit different, but for today's session, we're going to just be kind of having more of an informal discussion because we have smaller groups. If the groups get bigger, we'll do some breakouts virtually as well. We're going to jump into the topic of council composition, and I keep hearing myself say which Hegelney just told me on the weekend is like not a word, and so you know he's probably told half of you that. So for each topic, we're going to be looking at how things are currently set out for Witset under the Indian Act, how things would be for Witset if Chief and Council had decided to opt in to the First Nations Election Act, which they could do by band council resolution at any time if they wanted to. And then we're just going to talk about some alternative options and see what people think about the alternative options. And we'll do the same approach for every topic. With regards to council composition, right now, Witset has 1 chief and 12 councillors. Under the Indian Act, Witset is allowed to have 1 chief and 1 councillor for every 100 members. They cannot have less than 2 or more than 12 council members. So right now, Witset has maxed out the number of councillors that it's allowed to have under the Indian Act. Under the First Nations Election Act, the rules are exactly the same. However, council can, by band council resolution, reduce the number of council members on its council, but they cannot reduce that number to less than 2. When you look at alternative options that other communities have used, some of the things that they've done is use region-based positions, designated seats for on-reserve, off-reserve positions, youth councillors, elder councillors. They've set out a maximum number of terms in office. They've set out restrictions around immediate family not being allowed to sit in office at the same time. So this is kind of an area where there's a lot of opportunity for changing how things look for Witset. Some of the things that Witset needs to think about when they're deciding who do we want to have on our chief and council, how do we want it to be made up, is what are the ages of people in the community? Is there a need for succession planning? So succession planning is a process where you start looking at what you currently have as an organization, and in this case, as a First Nation, and what are the things that you need for new leaders in the future? Who's currently in the positions? Is there a diversity of who's in the positions? How do you pass that knowledge on? How do you do things in a way that you don't have a group of people who are, for example, aging and not passing their knowledge on, and other people aren't being included in band council? So looking at the needs of the community and the skills and knowledge that's required to meet those future needs. So that includes thinking about things like what type of businesses is Witset getting more and more involved in? What are some of the demands that there are on Witset for different skill sets to basically run the programs that Witset runs or administers and provide services to members? And who's going to be able to fulfill those needs? And then how are we going to train those people? So these are all things that are worthy of thinking about when you're looking at who's going to make up council. And it really leads to why a lot of communities want to have elder positions and want to have youth positions on council. And as communities become more diverse in where they live, some communities have decided that they want to have more off-reserve or out-of-territory representation. So in terms of Witset, there's 2,139 members that are registered. So this is the statistics that we receive from Indigenous Services Canada about registered membership. Of those members, there's 646 who live on Witset Reserve. So you have a very high percentage of population living off reserve. 66 people are living on other First Nations reserve lands. In terms of family size and representation, you'll know that best, and we'll talk a little bit about a legal case through the federal court, this Chipasia case that looks at a bit of a mishap that happened when a community had decided to have family-based representation, which is always an option for chief and council. In comparison, you look at the local government comparisons, for example, a city or a municipality. For cities and municipalities, the BC Community Charter says that if that city or municipality is more than 50,000 people in their population, there is a mayor plus 8 councillors. So that's for a 50,000 population, a council that's much smaller than what Witset has. And if there's less than 50,000, then it's a 6-councillor council. For towns or villages, which are, I don't remember the exact, but I believe this is what applies to the town of Smithers, right? Would be a mayor and 4 councillors. So just quickly looking at kind of a situation where a community had decided to have family councillors as representatives. So they decided there would be a chief, and then there would be 5 family councillors, and each family group would get to elect their own family councillor on who's going to represent them. The family councillors would then select the chief by majority vote amongst them. So this is Blueberry River First Nations, and this is what they set out in their election code. In their election code, 58% of people turned out for the vote, and 52% voted in favor. So the code passed. In this case here for Witset, you would need to have 50% plus 1 vote in favor of the code of all electors who participate in the vote on ratification later. The thing that was lacking from their custom election code in Blueberry River is that it did not say who belongs to what family group. So they didn't have a family grouping list. And so this led to some problems during their elections. In September of 2017, a councillor was asked to prepare draft lists of the names of who falls within each family group. That list was sent out to all of the electors to see if they had any problems with the lists and who was positioned where in the list. Then there was a notice of a nomination meeting because they had an election coming up, and the nomination meeting was scheduled a little bit late, but that's not what this case has to do with, so we're not going to worry about that. There was in November a group of members who filed a federal court application challenging the election code because they were placed in a family group that was made up of almost half of the electors, and they felt like their voices were being diluted. They could only elect 1 person for their group, which reduced the amount of power they had compared to other groups to be represented on council. So that was in early November, and then the day after this was filed, the nomination meeting was held, and then about 6 weeks later, the election was held. Nobody brought forward concerns about the family group lists that were distributed to members. So in September, the councillor sent out the list and asked for people to make comments, but nobody had commented. So the federal court decided, when they looked at the application that was put forward, that the applicant's rights were not breached. The rights that were at stake here was the right to equality, the right to equality before and under the law that's set out in the Charter of Rights and Freedoms. The court said that past Section 15 cases, so past cases that have to do with rights to equality, only recognize 4 different grounds upon which inequality can occur, based on being treated differently due to citizenship, marital status, sexual orientation, and place of residence in the situation where you have an Indian reserve and residence is a concern. In this case here, the people who raised the concern about the family groupings were asking the court to accept that Section 15 of the Charter of Rights and Freedoms that says you have to be treated equally also applies to your family status or lineage. And they argued that the election code creates a distinction that's based on that ground by how people were organized into family groups. The court said no, Section 15 does not apply. We do not accept that there can be inequality based on family status or lineage under the Charter of Rights and Freedoms. And they said, nope, we're not going to accept that. So the reason this is an interesting case when you're looking at how to set up your chief and council and the structure of it is that if you're going to do a family-based system, be very clear about who the family groupings are. And family status and lineage are not a basis upon which somebody can complain later to the courts. So we need to set out how family groups are determined and where each member would fall if they have no lineage. For example, if people are married in to the band or people have transferred into the band somehow, some other way. And I understand that there may be band members who have transferred in, but not through marriage. So in terms of other things that you will want to think about when you're looking at how to compose your chief and council is what are the Wet'suwet'en considerations? So what are some of the Wet'suwet'en stories from long ago, the songs, the history, the language, Wet'suwet'en laws and Wet'suwet'en oral traditions that teach us about how you relate to each other as leaders and members of the community. So who is a leader? Who do the leaders represent? What is their relationship to the people that they represent? And so we're going to have a very big group discussion on this when we do our in-person meetings. And then the second piece of this would be just talking about council composition. Who should make up chief and council? Should we change for Witset that there's one chief and then one councillor per 100 members? Should there be designated positions? What would that look like? Should there be also a maximum or minimum number of seats for councillors? So should there be right now there's a maximum of 12 councillors allowed at any given time. And then the other thing is looking at, should there be any restrictions on immediate family members being on council at the same time? And if yes, who do you consider to be an immediate family member? So I'm going to stop sharing my screen right now so that we can have a little discussion about this. And the first thing is just looking at Wet'suwet'en considerations. And we only have one participant today, but we still really value what you have to say. And we will be documenting what each person says in terms of their thoughts on the different discussion topics, but we will not say in our notes that we share with people who it is that said what. And I understand that the parts of this virtual meeting that are going to be recorded and that are going to be shared publicly with everybody will just be the presentation parts, not the parts about what we discuss. Okay, so our next topic that is up for discussion that we want to hear from community members about has to do with the term in office for a council member. So this includes looking at how long is the person in office for once they get elected. And under the Indian Act, there's a 2-year term. So all chiefs and councillors in a First Nation are elected in at the same time. Under the First Nations Election Act, this is different. It's a 4-year term, which is actually the same as what local, provincial, and federal governments use. And again, they are all elected in at the same time. Some of the things that other communities have had in their election acts or custom election codes, I should say, include moving on to a 4-year term and also having staggered terms in office. So if there's staggered terms in office, what ends up happening is during the first council election that's held under the new custom election code, there would be half the chief plus half of the councillors elected into office for a 4-year term. The other half of the councillors would only be elected in for a 2-year term. And then 2 years later, the ones that are elected in for a 2-year term, their terms expire and there's an election for those positions, and that election is done for a 4-year term. So what you end up having is elections every 2 years, but everybody stays in for 4 years, and you always have half of your chief and council continuing on into the next term. So you don't end up with these situations where the whole chief and council turns over and people don't know what's going on. In a big council for Witset, that might not be as big of a deal because you might have a lot more consistency in having people continue on in their terms. In smaller communities, it can be a really big deal because they can have all of their chief and council could be new. So you're the community and you know how that goes. You know how many times a position changes over and when there's consistency of the same person term after term. So maybe staggered works for you, maybe it doesn't. The other thing that we can look at when we talk about council term in office is whether there should be limits on the number of terms a person can serve in a row. And this, again, relates to that whole succession planning thing that we're talking about, making sure that future generations and future leaders are being developed in skill sets and being put into positions where they can become the leaders. And then you have this ongoing education of the new generation all the time happening. And so some communities say they want to have a limit on the number of terms in office because they're seeing an aging population. People are always the same people running. Nobody new is even trying to get in. They have concerns about things like, they say, career politician. And then some people say, nope, it doesn't matter. If they're voted in, it's because we want them in, then there should be no limit. People should be allowed to be on chief and council for their whole lifetime if they want to, as long as they have people voting them in. In a recent community that I've been working with, they were very divided on this topic. It was very close to half and half. Half wanted there to be a limit on how many terms in office, half wanted there to be an unlimited number of times a person can run for office. And so what we've done in their proposed election law, just as kind of, we haven't even gone to the next step of community review yet with it, but we've said there's going to be a limit of 8 years, but if you receive more than 50% of the vote of who participated in an election vote, then you can continue on past 8 years. So the threshold of number of votes you have to get to be in for more than 2 terms in office, 2 4-year terms in office, would be at least half of the membership supporting you. So some of the things to look at, you need to consider is the pros and cons of a 2-year term versus a 4-year term. And some of the things that we hear from community is that a 2-year term is just not long enough. In 2 years, especially when you're a new chief or a new councillor, you get into office. You basically learn what the new policies and procedures are, then laws that you have to follow are. You learn how the governance of the administration of the band works. And that takes at least a year. And there's just so much learning that happens in the first year that by the time that they get to the second year, it's already time that there's notices for the next election going out. And then everything gets political and messed up. And, you know, nothing, people start being more concerned about being reelected than they do about doing their jobs, and things get political. And with a 4-year term in office, people like that there's a lot more time for learning. There's a lot more time to settle into your role. There's time to make and learn from your mistakes and improve and also complete projects. So for example, this custom election law project is going to take a good 2 years until it's time, if it gets to the point where community says, yes, we're ready for this. Other projects like land use planning or things like going under land code, different things that First Nations want to think about doing, they often take more than 2 years. And so people have said in some of the other meetings I've held in other communities, we need the 4-year term. It allows council to start a project and see it through right till the beginning. Some of the downsides to a 4-year term that people expressed in other meetings I've held with other communities have to do with the 4-year term. Then we're stuck with them for that long. What if they're not doing a good job? There's no way to get rid of them. Well, that's not a problem because the community can decide in its custom election law what the different grounds are upon which you can get chief or councillor removed from office and hold them accountable for their conduct. So the pros and cons, I guess, when we move on to staggered terms in office, one of the things that people have expressed to me in the past about having staggered terms is that you're still doing elections every 2 years. It's exhausting. Community is just so sick of elections. It just seems like it's elections all the time. And having just 4-year terms in office where the whole council is voted in at the same time gives that break from the election fatigue that people are feeling. The benefits of the staggered terms in office is that you end up that people talk about, I'm just saying what people talk about in the meetings I hold with other communities at least, is that there's more time for transfer over of information. So you always have half of that council who knows exactly what's going on with everything in the administration, and the new council learns from them, and then that transfer of knowledge happens before the next election. And so you end up getting rid of the issue of knowledge not being transferred properly from one council to the next. The next thing with regards to so I already talked a little bit about the limits on the numbers of terms in office. I'm sure you have a lot of your own thoughts about what the pros and cons are to limiting the number of years that the chief or councillor can be in office. But I want to hear from you on these topics. So is there anything you wanted to share with us, Dilly? I know this is like, maybe if just to say, if you want us to just go and run through all the slides and then take time at the end for anything that you want to specifically comment on, because I know you're double tasking right now, just let us know. Is that a thumbs up to just continue on, I think?
Yeah, sorry.
Okay.
Yeah. Okay. And I'll be
Okay.
here listening.
Okay, and again, I liked your idea about doing like a follow-up meeting after people have time to think about these issues and these topics as well. So please, be patient with us, and we'll come back to you and let you know what the administration thinks of whether we can make some time for those additional meetings. Again, some of the things to think about from a Wet'suwet'en perspective. So what is it that the Wet'suwet'en stories, Wet'suwet'en songs and history, the Wet'suwet'en language, Wet'suwet'en laws, and oral traditions, what do those things teach us about how long a leader should be in their position at a time? What do they teach us about whether or not there's issues with what some people have said, career politics, right? And what do they teach us about the responsibilities of leaders passing information over to one another, and what it might look like to have staggered elections, and if does that fit within Wet'suwet'en ways to have systems that work that way? These are some of the things that I'm hoping that people will be able to have time to think about and put their minds to before they decide what the term in office, staggered term in office, and limits on term in office might look like. As I said already, we're not going to be talking about candidate eligibility during this session because that will be next week. So I'm just going to flick through the slides that relate to that. And the next topic that we're going to be talking about, it has to do with nominations. And so when we're talking about nominations, we're talking about looking at some of the issue. What are the issues that arise with regards to nominations and chief and council? And one of the things that people have talked to me about in the past is that the rules basically have no restrictions on whether or not you can nominate everyone. You can nominate every single person if you want to under the current rules. And then that's one of the things that people have said that can be a little bit problematic. And so currently under the Indian Act, nominations have to be in writing either before the meeting or in person at the meeting. So those are the Indian Act election regulations that Indian Act, and then it's Indian Band Council election regulations. It's a long word that set that out. And throughout the slides, you're going to see that there's little at 4.31, and the next one under First Nations election regulations at 9 subsection 1. Those are the specific sections of the laws that these summaries are coming from. And on the Witset website, there is a copy of the Indian Act, a copy of the regulations, a copy of First Nations Election Act, and a copy of the First Nations Election Act regulations that you can go to. And if you go to these section numbers, you'll see the exact language. Some people just like to see the very specific language that's in those laws. So that's just kind of a little I guess note on how that's depicted in the slides in front of you. So under the Election Act, it's the same as the Indian Act, but there's a restriction that you cannot run for both chief and council at the same time. You cannot nominate yourself, and you cannot nominate more people than the number of positions available. So for Witset, there would be 12 councillors and 1 chief, a person would not be allowed to nominate more than 13 individuals. And under the First Nations Election Act, council also, by way of band council resolution, can decide to impose a candidate fee. So $250 that up to $250 that each candidate would have to pay in order to run and be a candidate in the election. And then if that person receives more than 5% of the votes, they get that refunded to them. They get the money back. Other First Nations I've worked with have talked about eligible voters being allowed to make a nomination or second a candidate in a nomination, but only for 1 chief and 1 councillor for each. So they thought a limit of less than, in this case, 13 under the Election Act would be allowed, and that the candidates should have to pay a mandatory fee, that you should not be allowed to nominate more than a specific number of people, and that some people have in other communities said that you have to pay a nomination fee to be able to make the nomination rather than it be the person who accepts the nomination. Some communities have said, no, well, we need more than 2 people to support a nomination before we accept it. And a community I've been recently working with has said we want there to be basic training that is completed before somebody's allowed to accept a nomination. And so that includes what they talked about was making sure that people understand the roles that they're running as candidates for. They understand what a chief or councillor can or cannot do, what the boundaries of their authority are and their power are, so that people don't mistakenly run thinking that maybe, if I run, all my family members are going to be able to get houses at the end of the day because I'm going to be able to dictate that, right? Whereas it's, understanding, well, how do decisions at the band get made? Who's in charge of those decisions? What power does chief and council have to change the way things are, which is generally by making laws or making policies and procedures that the staff at the band office have to follow when they make decisions, but they're not chief and council are not the actual decision makers. So these are the types of basic training that this is the type of basic training that people have asked to see candidate complete before they can accept a nomination. So the nomination procedures in the current process under the Indian Act, there's a nomination notice that goes out, and I believe that there's one actively out right now for Witset, so you've probably seen a copy of that recently. Then there's a nomination meeting that takes place, and then there's an assessment of the eligibility to be a candidate, which right now is just to be a band member and be 18 years of age or older. Then the nominees accept their candidacy. And if there's not enough people running, so for example, if you have 12 councillor positions and only 11 people put their names forward, there's no election held. Those people just get acclaimed into their positions, so not directly placed in their positions. So some of the things that we talk about when we have our group discussions in the big groups is we look at the pros and cons of having person pay a nomination fee to run for office. And what are some of the good things that come with requiring a nomination fee? People have said, well, it means that they're serious about being on council. They're willing to put their money where their mouth is. Other people, in terms of what the cons are, have talked about, oh, that's not really fair because our people do live in quite a bit of poverty and they experience financial challenges, and a nomination fee could restrict somebody who is otherwise a really good candidate from running. So we might have knowledge holders, for example, in our community who are living on a restricted income through pension or some other type of restriction, maybe a disability income, and a nomination fee would just make it so that they're not able to run. And so that was some of the cons. And then people who said I've heard talk about wanting to see a nomination fee have supported having it returned if the person is voted in. Some of the people who've talked about having limits on the number of people a person can nominate, if we're going to move on to the pros and cons of that, they've talked about the limits being something that helps ensure that there are more people supportive of a candidate being elected before that candidate gets elected. And I'll give you an example to make that make sense. What happens if you have 100 people who are eligible to vote in an election, and you have 15 people running in that election. Of those 100 people would need to vote in favor of a person for them to get in. Now, imagine there's 30 people running in that election, but there's only 100 votes to go around, right? If you have 30 people running an election and 100 votes to go around, you need fewer people saying, yes, we want that person in for them to get in. And I've seen situations where you have 30, 40 people running in an election and somebody gets in a community with 1,000 or so electors with like 37 votes, and that's because the votes get split amongst a whole bunch of people, as opposed to people focusing on who they really want to have in. The votes just get split so widely that people can get in with a very few votes. And so that's the main reason people think that it's beneficial to limit how many people a member can nominate as a candidate. When you're looking at how many people should sign off on a nomination for it to move forward, this is something that I would say majority of people I've talked to in the past in other communities have been happy with the 2 people approach. There's always a few people that want to see a higher number of people be like basically a petition for nomination and have like 10 people sign it or more people sometimes. So we have a couple survey questions that are going to be very simple in these regards of what people want to see with regards to nomination rules and procedures. And then I already said that the campaigning offenses and all candidates forums piece will be covered in our other sessions. So campaigning offenses, those will be covered on, oh, I don't see it. Okay, no, campaigning and offenses in all candidates forums is part of nominations. My bad. We are going on with this. So with regards to campaigning and offenses under the Indian Act, for the most part, it's silent about what illegal campaigning is. However, it does say in the Indian banned election regulations that a person shall not interfere or attempt to interfere with voting or ask someone how they voted while at a polling station. And also under the Indian Act, it says that if a corrupt practice occurs, the Minister of Indigenous Services Canada can set aside an election. And Indigenous Services Canada gets to decide what a corrupt practice is and what is not a corrupt practice. And then if they decide a corrupt practice did occur, then they can declare the chief or councillor's seat in office to be vacant. Also, if they find that that chief or councillor accepted a bribe or they were guilty of some other offense in connection with the Election Act, guilty of dishonesty or malfeasance, which is a misuse of their position in office, essentially. First Nations Election Act and regulations, if Witset were to opt into this, says a lot more about campaigning offenses. It's a little bit more detailed. So a person is not allowed to, by intimidation or duress, attempt to influence another person to nominate or refrain from nominating a particular person as a candidate. Also cannot accept or decline a nomination or withdraw as a candidate. So basically no intimidating and creating situations of duress, so pressure on people to decide who they're going to nominate or who they're going to accept, or if they're going to accept a nomination. Also not incite other people, so not encourage other people to do the same, not encourage people to act in a disorderly manner, not to encourage or be involved in disrupting the conduct of nomination meetings, not to be publishing false statements about a candidate withdrawing, and must leave a nomination meeting for any of these types of behaviors if the electoral officer asks them to. There's also restrictions around campaigning nearing polling stations, and that the people cannot obstruct the electoral officer in the performance of their duties. The First Nations Election Act also has some information in it around what the penalties are if somebody gets found guilty of doing one of these things. And basically the penalty has a highest fine of $5,000 and an imprisonment of up to 5 years. I am not aware of anybody who has been imprisoned for this, and I would have to do an updated research on our legal databases to find out if there's been any recent cases that deal with highest fines where somebody's been actually fined. In British Columbia, to give kind of a provincial example, People are not allowed near election offices and voting places. Vote buying is an offense. Intimidation is an offense. Corrupt voting is an offense. And interfering with the election officials' duties is also an offense. The penalties in the British Columbia context this is when you're voting for a member of legislative assembly for the provincial elections, is the penalties for doing these things would be up to a $20,000 fine, 2 years in jail, as well as being prohibited from being a candidate running for offices and from voting in elections. So there's a 7-year prohibition on voting, even if you are engaged in any of this behavior. So that's pretty much it with regards to campaigning and offenses. And there's a series of questions that we have in our survey that will be going around, as well as, of course, we invite people to have discussion about what should be a campaigning, what should be considered illegal campaigning. Also, what should the penalties be? Because the penalties look different depending on the community and what they want. The Indian Act and First Nations Election Act are also silent on all candidates forums, and I'm not sure if Witset uses all candidates forums during their election, but an all candidates forum is essentially a debate where candidates get provided an opportunity to express their views on different topics. So you might see these in federal elections and provincial elections on the news during election period. It's pretty common in the bigger kind of election context. And they're always facilitated by a neutral third party, and that person asks questions, and each candidate is provided equal amount of time to respond to the question. So the idea is to give people the benefit of understanding the views and perspectives of who it is they're considering voting for. So there could be different formats that get used for this. It could be online, it could be in person. The First Nation I'm a member of, Tlaitli, we do them very informally, just in the band. People who are running for the election generally set them up. Other communities I know have this as kind of a mandatory thing that they do. So during the bigger groups, we'll be spending some time looking at the types of campaign activities that should be restricted and people having some group discussion about it, and then group discussion about what should the consequences be if those campaigning restrictions are somebody does something that is restricted in campaigning. Also looking at whether there should be all candidates forums, and if yes, what should they involve. The last kind of grouping of topics for tonight's meeting, and I'm hoping to hear from Dilly afterwards about some of these topics and what you'd like to see if you were to wave a magic wand and have your own rules in place today. The last topic is voting rules and procedures. So the types of voting right now include mail-in ballot and in-person voting under the Indian Act. So the electoral officer will send a mail-in ballot to all off-reserve voters whose addresses are on the elector list that gets provided to them by Witset. Up until the election day, the electoral officer can also send a mail-in ballot to any voter who requests one. But if a person has already received one and they request a second one, they have to sign a declaration saying that they lost it before the second one gets provided to them. If a voter is unable to mark their own ballot, they're allowed to enlist the help of another person to do so, and there's a formal process for filling out who did that for them and how they marked it, how they were instructed, etc. Under the First Nations Election Act, if Witset were to take that approach of opting into First Nations Election Act, members who wish to vote by mail-in ballot have to provide a written request. So it is not sent to all off-reserve voters. And they also have to send a photocopy of an identification document confirming who they are, so that the electoral officer can then confirm their identity before sending them the mail-in ballot. And then if a voter is unable to mark a ballot, again, there's an opportunity for them to get help from somebody else, and that's set out, the rules around that are set out in the Election Act and regulations. With regard to in-person under the Indian Act, the advanced polls are not included. So when we have, for example, a provincial election, you probably noticed that you can go vote at some advanced polls before the date of the actual election. So there'll be, for the last 2 weekends before the election, maybe there'll be advanced polls open. That's not something that's in the Indian Act. At least one polling station must be on the reserve. In-person polls run from 9 a.m. to 8 p.m. and candidates can have two agents observing at a polling station. If the First Nations Elections Act were to be adopted by Witset, then there would be an option for the electoral officer to hold advance polls between 5 and 10 days before the election. They could do so both on and off reserve. However, at least one polling station has to be on reserve, unless there's certain circumstances where the electoral officer is unable to do this, then it has to be as close as possible to the reserve. For example, maybe there's no neutral space on the reserve for this to happen, and you have to go to a community hall that's just off the reserve boundary. That would be kind of example of that. In-person polls are from 9 a.m. to 8 p.m., so it's the same as under the Indian Act. And again, same as under the Indian Act, candidates can have two agents observing at the polling station. So the biggest difference between the Election Act, First Nations Election Act, and the Indian Act is that the First Nations Election Act specifically allows for advance polls to be held, and that's the main difference between the two. If you were to compare this to how things work in the provincial election, in provincial elections, mail-in ballots are by request only. Advance polls are set up both weekends before the election day. You can also vote in advance at a district electoral office. So different places are designated as voting spots that you can go to anytime during business hours. And there's also in-person voting on election day. Those are assigned locations depending on what region you live in, but you can vote anywhere as long as you have documentation showing which region you're supposed to be voting in so that your vote counts for that region. When we talk about this stuff in big groups at the in-person meetings, the things we're talking about are what types of voting should be available, why, how should the voting be done, and when. So for example, mail-in ballots. Should the mail-in ballots be available? Who should get a mail-in ballot? Is it everybody who lives off reserve? Is it everybody that lives outside of 50 kilometers from the reserve? Is it only people who requested the mail-in ballot? What would somebody need to give to the electoral officer to request a mail-in ballot? If it were in-person voting, then should the in-person voting include an opportunity for advance voting if that's something that the band has the financial means to support? Is it something that should allow for longer hours? Maybe 9 a.m. is too late to be opening the polls. Maybe people who have to be at work at 9 a.m. want to see the polls open at 7 a.m. so that they can go in on their way to work to vote. Maybe they want to have longer hours for voting to be open. Maybe they want to have a requirement that there be a voting station, for example, in Smithers, because so many members live in the city, not in Witset. So these are some of the things that could be discussed at the in-person meetings. And with regards to the idea is, should there be maybe online voting available? Is this something that council should be allowed to direct at the time that they put out their notice to hire an electoral officer, depending on how much money the band has and if it has the financial capacity to support online voting? With really small communities, I have had them say that they want to have virtual voting basically through Microsoft Teams or Zoom, and that the person could tell the electoral officer how to mark the ballot for them, and that they would have the electoral officer mark the ballot for them. They would show their ID virtually online. That would be enough to confirm their identity, and then they would be able to vote without having to go in. I've also have one very small community that I'm familiar with that does on the phone voting. With larger communities, this can be a little bit more of a challenge because you have such a big community, it could be harder to validate who the person is calling in. Whereas if it's a small community, everybody literally knows everybody, then it may be a little bit easier. You could even recognize their voice on the phone, right? So these are the different things with regards to voting options and procedures that we've been asking members to consider.